I've been asked a lot of late, what are the issues with initial coin offerings and why do they wind up leading towards so many different types of litigations? The answer typically is because coin offerings and tokenizations are sort of a new play on raising capital. And if you're raising capital, but doing it through tokenization, and even if you're taking Bitcoin as payment and trying to say that the tokens that are being issued to you don't arise to securities, the reality is that the SEC has not fully determined whether or not such an ICO is in violation of the securities laws. Now, what does it mean if you're in violation of the securities laws? If you've gone ahead and you've raised capital, but you've done so in a way that you never registered with the SEC, didn't utilize a prospectus or didn't have a PPM, didn't follow the Securities Acts, then you could wind up in a scenario where people could argue, first of all, the SEC could initiate an action against you, but moreover, as for your investors, they could be entitled to a rescission of their investments, meaning that they're entitled to a return of the entire amount that they invested with you. So when you're doing an ICO, you want to be really careful about the ways that you're going about things. You want to be careful about understanding the way the business practice is actually going to work. That is very, very important because you want to be as certain as possible that the funds that you're raising aren't going to be classified as a security, therefore subjecting you to violations of the securities laws, fines, and rescissions of the investments made by your investors.